Hello, everyone. Welcome back to Immigration Fridays, your weekly dose of clarity in this complex world of US immigration. I'm your host, Prashanthi, and today we're tackling a question I get asked all the time. Can I come to the US on a tourist and then can I switch to a work visa? That's a fantastic question, and the short answer to it is yes, it's possible. But it's a path riddled with nuances and pitfalls. So grab your notebook because we're about to decode the journey from a B1, B2 to a work visa. First, let's understand the basics of a B1 visa. A B1 visa is for business visitors attending conferences, negotiating contracts, or consulting with business associates. A B2, on the other hand, is a tourist visa for sightseeing, visiting friends and family, maybe medical treatment, etc., etc. Critically, neither of these visas allow you to work in the US or for a US employer. That's a fundamental principle that we should never forget. So, if you're here on a B1, B2, you cannot start working. End of story, right? Well, not quite. The process we're talking about is called a change of status. This is where you can possibly apply to the US to change your non immigrant status category while you're physically present in the US. So, what is a change of status application? Now, here is where it gets tricky. When you're applying for a B1, B2 visa, or when you enter the US on one, you are you're signaling that to the US government that you have no immigrant intent. And that means that you intend to return to the US within the authorized time. If you enter with a preconceived plan to stay and work in the US, then that's considered to be visa fraud. And that's a huge red flag. And that is considered to be an unlawful entry. So, the first and most critical step that you have to understand and remember is do not enter into the US on a B1, B2 visa if you already intend to change to a work visa. So, intent is very important at the time of entry. But let's say your circumstances change. You came as a tourist and you genuinely intended to go back within your authorized time on your I-94, but then an unexpected job offer came your way. Perhaps you were networking and a company was incredibly impressed by your skills. In such a scenario, a change of status might be a viable option. So let's look into the process. Here's a general roadmap for a change of status from a B1, B2 to a H1 or an L1 or an O1, or whatever other category work visa that might exist. First step is to secure a job offer. This is the foundation. You cannot apply for a work visa without an employer and without an offer of employment. So US employer must be willing to sponsor you for the job. And if it's a H1, then it has to be a specialized position. If it's an L1, then there are other requirements. O1, there has to be extraordinary ability. So you have to obviously meet the standards of the work visa that you're applying for. Second step is file the work visa. Your sponsoring employer will file an I-129 form and I petition with the USCIS. This petition outlines the jobs, outlines your qualifications, has a request for change of status in it. And of course, you have to remember that if you're on a B1, B2, and you've never been on a H1 before, then you have to remember the lottery. You will be subject to the lottery, and then timing is very important in such a situation. Step 3 is maintaining your B1, B2 status until your H1 actually gets approved, especially if it's a H1. Because your H1, if you're subject to the cap, your H1 will be approved for a future start date because you'll be filing in advance. Even if you file in June, which is the last date that you can file a cap case, June 30th, you have to show that you're in status as of October 1st because as I said, you're filing in advance and the start date in the case of a H1B lottery is October 1st. So you have to show that you're in B1 or B2 status until October 1st. Of course, if you qualify for an L1 or if you qualify for an O1, you can file for an immediate change of status application. And then all you have to show that you are in a B1 or B2 status as of the date of filing. So while your change of status application is pending, you must maintain your B1, B2 status, and you should not overstay your I-94. So in the case of a H1 especially. So if it's about to expire, then my suggestion is to file for an extension of the B1, B2 to extend that gap. So it becomes a little messy, especially in the H1 situation where the start date is some future date. But if it's not a H1, then the timely file rule is important because it allows you to generally remain in the US while your petition is pending. It's called a period of authorized stay. However, you still cannot work during this period of authorized stay. Then the next step, or step 4, is if your change of status is approved, USCIS will issue a I-797 approval notice. This notice will indicate that your new non-immigrant status that you have a new non-immigrant status, and it'll also indicate the validity period. It'll also show the date that your new status becomes effective, and this is critical. This is when you can legally begin working for your sponsoring employer. And as I said earlier, in the case of a H-1B, the status will be October 1st. In the case of an L1 or an O1, for example, or a TN, this will be an immediate start date. There's some key considerations that you have to keep in mind that we already touched upon a little bit, but I'll go into more detail. The 90-day rule. While this is not an official regulation, USCIS officers often scrutinize a change of status from a B1, B2, and they apply the 90-day rule. If you are filing for a change of status within 90 days, it kind of creates a presumption that you had the preconceived intent of filing for a change of status when you entered into the US. And this, while it's not an absolute bar, might make it challenging for approval of your case. Another consideration to keep in mind is the last action rule. If you travel outside the US, let's look at what happens with travel. If you travel outside the US while your change of status application is pending, then your application is considered to be abandoned. At least the change of status portion of it. Your H1, if it's a H1, will be approved for consular processing. So also you have to keep in mind if you leave after you get the approval, and if you've started working on a H1, that is the date of approval has actually passed, and then you leave, then of course you cannot re-enter on a B1, B2, then you have to go for a work visa. You have to go to the consulate, and if it's a H1, then you have to get a H1 visa approved at the consulate in order to come back on a H1. Let's now look at the timelines and premium processing. Premium processing times USCIS times can, as you know, be very long. It can take 4 to 6 months. So premium processing is available for some of these work visas. And while it adds significant cost to the process, it might be worth it because the waiting time for premium processing is only 30 days, while the normal processing can take 4 to 6 months. Another consideration when you file these kind of change of statuses is legal representation. Hire an experienced immigration attorney. This is not something that you can do yourself. An experienced immigration attorney can help you navigate the complexities and advise you on best strategy. They can also help you prepare a strong petition and help you respond to any RFEs, and also help you with reference to timing and extension of your existing B2 status. Because as I said, there's so many things to keep in mind when you're filing a change of status, especially from a B2 to a H1. They can help you present your case in a compelling manner and overcome any kind of immigrant intent presumptions. So to recap, while it's possible to change from a B1, B2 to a work visa, it's not a backdoor entry strategy. It requires genuine change in circumstances. and some planning and strict adherence to the immigration laws and often professional legal guidance. In addition, if USCIS thinks that you're applying for a change of status to circumvent the H-1B proclamation, wherein you have to pay $100,000 for any new H-1s, while a change of status application you do not have to pay the $100,000. So if you think you can come in on a B2, file a change of status in order to circumvent the proclamation, presidential proclamation, then you have to think again, because they might deny the case based on this itself, if they suspect that that's what you're doing. So keep that in mind as well. Understanding the intent behind your initial visa and entry is paramount. If you're genuinely interested in working in the US, the most straightforward path would then be to simply apply for a H-1B or a work visa from outside the country, rather than coming in on a visitor's visa and then applying. And that's all for this week, this week's Immigration Friday episode. I hope this episode has helped you clarify the path from tourist to talent. If you have questions about your specific situation, I strongly encourage you to consult with an experienced immigration attorney.